Dustin, thank you so much for joining us this morning for our presentation on the E-2 visa. My name is Dustin Saldarriaga, and I'm a senior associate with Scott Legal PC here in New York City. I am going to be joined by my colleague, Jiyae Hwang, who is also a senior associate with the firm and has extensive experience preparing E-2 visas. So we're very fortunate to have her joining us momentarily as well. Before we get started, I wanted to go over a few items beforehand. The first is that even though the E-2 visa, what we're going to be talking about today, is the most popular visa at our firm and is a business-related visa, our firm does handle the full spectrum of U.S. immigration law. So if you have questions about family-based immigration, green card options, temporary visas like student visas, visitor visas, really anything related to U.S. immigration, we do hope that you'll reach out to us. Additionally, after this presentation, we're going to send you an email, and in that email, you will have the PowerPoint presentation that you see on your screen, as well as a comprehensive guide on the E-2 visa. We'll also send you a link where you can sign up for our future webinars. We do try to do at least one of these webinars a week, and they do run, again, the full spectrum of U.S. immigration law. Each of our webinars is posted to our YouTube channel. So this webinar is being recorded, and that also means that you can go on our YouTube channel, you can see our past full-length webinars, and on our YouTube channel, you can also see shorter videos that we have, again, on a variety of immigration topics. So we do hope you'll check that out. If you have a question during the presentation, please do send it in using either the chat function on Zoom or the Q&A function. I am monitoring those. We will likely save all questions for the end of the presentation, but I do plan to get through all of those before the end, so please don't hesitate to send in those questions. One last point before we get started is that I think something that really sets our firm apart is that our founder, Ian Scott, has personally navigated this visa, the E-2 visa. In fact, our firm was started on an E-2 visa, as well as a number of other visas. So he has personally navigated a TN, an H-1B visa, a F-1 student visa. So that perspective of having navigated the process personally really does inform the way that we work with our clients, and we do really believe sets us apart. So without further ado, let's go ahead and dive in by talking about the E-2 visa requirements. And for this, I will pass it off to my colleague, Jiyae.
Thank you so much, Dustin, for the introduction. Yeah, so let's get started. What are the E-2 visa requirements? So as many of you may already know, an E-2 visa is a visa for entrepreneurs. An E-2 visa is a non-immigrant visa for investors who are seeking to come to the United States to develop and direct a U.S. enterprise that they have invested in. So let's dive into the requirements. So the first requirement is that you need to be a national of a treaty country. And what does that really mean, right? So the E-2 visa is an option available to nationals of certain countries that have signed an economic treaty with the United States. And this does include many countries around the world, a high number of countries actually, in all continents. And for some examples, Canada, Mexico, the UK, New Zealand, Singapore, South Korea, Jamaica, Philippines, etc. Many different countries across the globe have signed such a treaty. Now, it is not available to nationals of certain countries that have not signed such a treaty. For example, India, China, and Russia are three examples of countries that do not participate in the E-2 visa program. However, if you are a dual national of a non-treaty country and a treaty country, you can use the treaty country's passport to apply for the E-2 visa based on that nationality. So that is a very important thing to note. Now, when we speak of nationality in the E-2 visa context, we mean not about your country of birth, but we mean a country where you have a passport in. So treaty country nationality is different from the country of chargeability when we talk about the green card or immigrant visa context. So if you're a dual national, as I mentioned before, you can, and one of your nationalities is a treaty country nationality, you can qualify for the E-2 visa based on that nationality. Now, the other requirement is that the E-2 company, which is the U.S. enterprise that you're seeking to qualify for the visa with, must be at least 50% owned by nationals of the treaty country. And this goes into the also goes into the develop and direct requirement as well, where if the treaty investor is at least 50% owner of the enterprise, you will be able to prove that you have this control over the enterprise and can exercise that required direction. Now, the other requirement is that the applicant must make a substantial investment in the E-2 enterprise, the E-2 company that you are seeking to develop and direct in the United States. And what does substantial investment really mean? So, the first thing to think about is that investment means placing funds at risk. So, a common question that we get is if an applicant is preparing to set up a new company, for example, and if the applicant transfers a large amount of funds from their personal account to the E-2 business bank account, and the person may ask, I transferred money from my personal account to my business bank account. Is that enough to count as an investment? And unfortunately, the answer to that question is no, because when the consular officer looks at that arrangement, it is very easy to pull out any amount of capital if the money is just simply sitting in a business bank account. Now, when we speak of funds being placed at risk, it shows a degree of commitment to developing and directing this new enterprise. So when we're preparing an E-2 application and showing of substantial investment, we want to make sure to show that a lot of that money has actually been spent on concrete things, such that it is not just money that you can simply take back into your personal bank account, but really capital placed at risk through being spent on tangible expenses that are usually related to setting up a new business, if you're setting up a business. Now, if you are purchasing an existing U.S. enterprise and using that to qualify for the E-2 visa, then there is another option you can use if you want to hedge against the risk of the E-2 visa being potentially denied, which is an escrow purchase arrangement where you and the seller would negotiate that the purchase funds, that the money that you would place towards the purchase will be held in a third-party escrow account. And with the sole condition of that escrow being released to the seller being the approval of the E-2 visa. So as long as you have that sort of arrangement where the only condition of the release of the money in the escrow is the approval of the E-2 visa, then that also can be considered as funds placed at risk to meet the investment requirement for the E-2 visa purposes. So that is one option you can consider if you are purchasing an existing enterprise to qualify for the E-2 visa. If you are setting up a new startup in the United States, an escrow arrangement is not really possible. So in that case, you must definitely consider investing the money in concrete expenditures that are related to, the things that you must prepare to set up a real and operating business. Now, substantial investment. Let's talk about the substantial aspect of the investment. How much investment is enough? Now, there is no specific dollar amount that is required in the regulations to count as a substantial investment, but it does need to be substantial in that you need to be able to convince the consular officer that you have made, in fact, all of the expenditures necessary to get that particular type of business up and running. And the required amount of investment to be considered as substantial will necessarily depend on what kind of business it is. So, for example, if you are developing more like consulting type, office business where, maybe you don't need that much of expensive upfront equipment. Maybe you just need a laptop and, a place to meet your clients. Then maybe a lower amount of investment is enough. But let's say if you are, setting up a restaurant, or if you're setting up a retail type business where a higher amount of inventory may be required, for example, or more elaborate pieces of equipment if you're doing an manufacturing type of business or something like that, then, the needs and requirements of that particular business to become operational will, inform the consular officer's judgment on what amount of investment will be considered substantial for that particular purpose. Now, the third thing to note when we speak of substantial investment for the E-2 visa is that it is very important to be able to clarify to the officer where the money came from that you used to invest in the E-2 enterprise. So the source of funds must be able to be explained, and you need to be able to provide objective evidence of where that money came from. And any legitimate source really is fine for the E-2 visa, except if you are using a loan, the only requirement is that the loan must not be secured by the E-2 business or the assets of the E-2 business. So if it's an unrelated loan, secured by your residential house, for example, that can work. Or if it's an unsecured loan, like a line of credit where there is no security, those types of loans can work for a valid source of funds for E-2 investment. But you do need to be prepared to provide evidence of that source. So if you, let's say you sold your own property and use that sales proceeds to make the investment into the each enterprise, then you may want to provide a copy of the purchase sale agreement describing, the property that was sold and the money that was deposited to you as a result. If you're basing the source of funds on a loan, then you want to provide a copy of the loan agreement, clarifying what is the security for the loan, for example. Let's say you are getting a gift, and gifts are possible as a valid source of funds. But if you are using a gift, then not only do you need the gift letter from the person who is gifting you the funds, confirming, that this is a gift, but also you want to go one step further and clarify where the person who gifted you the money earned that money from. So let's say, you received a gift from a cousin, and the cousin earned this money from employment income, then you would also ask your cousin to provide, the cousin's income tax returns for the past year or the past 3 years, for example, to show that the cousin has, in fact, earned that money through employment income. Such that, you can clarify where the original source of the money was from. So definitely, while a wide variety of legitimate sources can apply to qualify for the E-2 visa investment, you do need to be prepared to present the documentary evidence to substantiate this factor. All right. So the other requirement is that the business must be real and operating. And what does it mean that it is real and operating? It means that basically the business must be ready to open its doors by the time you appear for the interview, to qualify for the E-2 visa, such that anything that is necessary for the business to become operational must already have been secured. So, for example, the legal entity in the United States must already have been established. If your business is a type of business that, has an office, a physical office, then it is a very good idea to already have that commercial business space lease in place so that you can show that you have the office ready and set up such that you can open its doors. If your business is a type of business that requires equipment, so let's say if you are going to run a gym, then you do need to show that all of the equipment that is required for the business to be operational has already been purchased and secured and set up in a way that it is ready for customers to use. So one good example is that, if a consular officer asks you, and if you are in fact qualifying with a gym, if I were to walk into that gym today, what would I see? And if you can describe that, the reception area is ready, all of the equipment is all purchased and set up, and all you need to do is, flick open the lights, and then, you can basically welcome clients basically the day after you, receive the visa and, arrive in the United States. So that kind of completeness in the preparatory steps is what the government is looking for when you are qualifying for the E-2 visa. Now, let's talk a little bit about hiring U.S. workers, and that goes to the requirement of marginality. Now, for the E-2 visa, in order for you to qualify for the E-2 visa with a business enterprise, that enterprise must be more than marginal. That means the revenue generation potential of the E-2 enterprise must be more than what is necessarily enough to sustain one person, the investor, and their immediate family. So this, in a straightforward way, this means that the business must have the capacity to hire other U.S. workers other than yourself to operate. And the government doesn't really want you to be the one who's doing all of the work for your business. It can't really be a one-person shop, right? So if you're just a solo consultant, for example, if you're not going to hire anyone else, but you're just going to be the only one who's working, then that's actually not the type of business that the government is looking for when they are adjudicating an E-2 visa. They want to see an enterprise that will actively hire U.S. workers, ideally at least 3 to 4 full-time U.S. workers by year 5 of operations. And it is okay if it is a small business, but definitely the profit generation potential must be enough, must be greater than what you would normally expect one individual to make when a person is working. So definitely one thing to consider when you're describing the scale of your business in the United States. So the final requirement is that the E-2 visa is a non-immigrant visa, which means you do need to convince the officer that your intent to come into the United States to develop and direct a business is temporary, and that you do have the intent to return to your home country after your business project is completed. Now, one thing to note, though, is that there is really no lifetime limit to how long you can be on an E-2 visa, as long as you continue to meet all the E-2 visa requirements that we just discussed. So, so you can continue to renew your E-2 visa as long as your E-2 enterprise is, meeting all of the requirements and is, operating healthy and hiring U.S. workers and hiring, that required amount of revenues and profits. So really there is no lifetime limitation on, how long you can be on an E-2 visa, but it is definitely one requirement. And usually it is enough to convince the government of this if you provide a signed statement confirming your intent to depart after your E-2 business project ends. And different types of cases can have different risk profiles with regards to the intent to return piece. And definitely you want to speak to a lawyer to, discuss more specifically on those facts. All right, so let's dig a little deeper into the rules and regulations relevant to applying for an E-2 visa. There are 2 options for obtaining an E-2 visa generally. So the first option is if you establish your own startup in the United States. And the second option is if you're purchasing an existing business in the United States and you obtain that majority interest as required by the regulations. And the advantage of using a business purchase to qualify for the E-2 visa is that you can actually use an escrow arrangement if you want to hedge against the risk that your E-2 visa may be denied, as long as the sole condition of the E-2, the escrow funds being released is the approval of the E-2 visa. The escrow cannot have any other conditions. Otherwise, the government may not think that it is investment properly placed at risk. For how long is my E-2 visa valid? Now, that is a very important question to think about. Now, the validity of your E-2 visa will depend on your country of nationality. And you can look that up by Googling reciprocity schedule, Department of State, and you'll be able to look up. For many, many countries, the E-2 visa can be valid up to 5 years. But for some countries, the validity of the visa itself can be as short as 3 months. Now, one thing to note is that the length of an E-2 visa is different from the length of E-2 status, which is granted at every entry, and it is granted 2 years per entry when you come in. Now, the visa validity period is the length of time during which you are able to travel with that visa. And you can think of it like a ticket to obtain admission to the United States. But the length of E-2 status is the length of period that you're given at entry on how long you're allowed to remain in the United States once you are admitted in with your E-2 visa. So let's say even if you have, a 3 months valid visa, as long as you, apply for admission within those 3 months, at entry, you will actually be given 2 years to develop and direct your business. Even if your visa itself expires, you'll be able to stay a little bit longer in the United States on E-2 status as you need to. The only thing is once you leave, then you will probably need a new visa stamp to come back because the visa stamp needs to be valid when you try to enter. Now, let's look a little bit about some of the differences that can come in with consular officers making a decision at the interview. If the consular officer thinks that maybe they want more proof that the business is, not marginal, for example, or if you have actually hired employees, for example, the consular officer does have the discretion to issue a shorter period visa. And we have actually seen that happen in some cases. So even if, the maximum period that you could get, that someone of your nationality can get an E-2 visa is 5 years, depending on the facts, maybe, at the end of the interview, the consular officer will only issue the visa for 3 years, for example. So definitely, yeah, there can be a little bit of variation on case to case, but generally it will follow the reciprocity schedule for under the Department of State list. So the I-94 timing of 2 years, that is what I just explained. The once you come into the United States on the E-2 visa, you will be issued what is called an I-94, and you can actually check your I-94 after every entry online. You will be able to print that out. And the expiry date of the I-94 that you see there, that date will control how long you have in the United States to continue staying on E-2 status. So even if you have a 5-year visa, once you come in and get 2 years of status, you do need to leave within the period given in your I-94. So the I-94 date is the date that controls the authorized length of your stay. So that is definitely a very important distinction to keep note of. All right. So now let's dig a little bit more detail about the amount of investment that is usually needed to qualify for the E-2 visa. As I mentioned before, there is no hard and fast minimum in the regulations or law on what dollar amount would qualify for the E-2 visa, but it needs to be substantial, and you need to be able to convince the consular officer that your investment is indeed substantial. And what amount of investment is substantial depends on a variety of factors. It depends on the type of business, as I mentioned a little bit before in the previous slides. It also depends on where you apply, which consulate in the world that you apply to, and perhaps also the individual examiner who is looking at your case. Also, what is relevant is the overall strength of your case. So even if the objective dollar amount of your investment is a little bit on the low side. Let's say your E-2 enterprise is already making revenues because it has clients in the United States. Let's say your E-2 enterprise already has hired employees and a manager and, is already operational. Or let's say you already have very high value contracts that you have executed between your E-2 entity and American clients. If you can really show the strength of those kinds of other evidences relevant to marginality or real and operating, for example, maybe that will also positively influence the government officer's decision on whether they think that particular amount of investment is enough to, create that kind of valid business for the E2 purposes. So the overall strength of her case is definitely an important factor when we consider how much investment is substantial. Now, let's briefly go over the proportionality test, which is really primarily applicable to startups. And the proportionality test basically is that the smaller the total cost needed to set up or purchase a particular business, the higher proportion of these costs must have already been spent. For example, if you are qualifying with a smaller business, that only requires, let's say, $100,000 to set up, then the government will expect that you have spent all of the $100,000 required to set up a company like that. By contrast, if you are trying to say you made a substantial investment into a $10 million enterprise and you've made a $1 million investment towards that enterprise, then even if you've only committed a small portion of the total cost required, because the cost required to set up that kind of business is so high, it is likely that you will be able to qualify with a smaller proportion of the money spent. But the important thing here to note is that if you are qualifying with a smaller business, the government will expect to see that you have spent all of what is required to get that company to an operational point. Now, if you are buying a business, the substantiality inquiry is really comparing the price that you paid to purchase the business versus the fair market value of the business. And this is really more relevant if you are not buying the business out of the open market. So if you found the business purchase opportunity in the open market, then it is likely that the actual purchase price you paid is in fact the fair market value of the business, because that's the definition of a fair market value, how the business is valued in the open market. But if you purchase the business through an acquaintance, somebody that or, in a closed network, by someone, a network of someone that who knows somebody. So if you have purchased the business in a closed market transaction, then it may be a little bit more important to be able to show that the money that you paid for purchasing that enterprise is equivalent to the fair market value. And you can try to prove that through evidences like getting a letter from an independent CPA, certified public accountant, who can, look at the performances of the business and assets and things like that, and confirm that the fair market value of the business is in fact equivalent to what you paid to, to acquire that majority share in that business. So having that independent confirmation can be helpful in that particular case. Now, franchises can be a good option for E2 visas, especially, if you are looking at a lower investment amount. Any fees that you pay on securing franchise rights can be included in your investment amount, so it can be a good way to boost your investment amount. Another advantage that franchises can provide is that you would likely get a startup package with the franchise, providing some assets for marketing or some know-how you can rely on to start your business in the right way. And so it may be better for, things like real and operating and marginality, if you can get that support, and the consular officer may positively regard that as, indicators that this business would likely, have good support when it's hitting the ground running. Now, let's talk a little bit about common good and bad E2 visa expenditures in the case where your setting up a new business in the United States, can any and all expenses that you incur with relations to setting up the business can be included in the E2 investment list? And the answer is no, because certain things like, let's say you purchased a plane ticket to travel to New York to, talk to some business partners. Can I include the plane ticket as one of, my E2 expenditure items? And the answer is no, we do not recommend that because we really want to focus on things that are more obviously related to, setting up the business itself. Things like any rent paid towards office lease. That can be one good example of a good E2 visa expenditure. Any legal fees that you pay to set up the business, negotiate the lease, any contracts or things like that. Legal fees can be included as part of this startup, investment. What about any money that you pay to accountants in setting up the payroll system? And what about, any salary that you pay to employees? All of those expenses can legitimately be included as part of your costs in setting things up. What if you're, setting up a business website, to set up that online infrastructure uh, to rope in clients, that could also be a very legitimate expense. If you're setting up ads, online ads, through social media, things like that, you can even include those types of expenses. So there can be a good variety of categories of expenses you can include as part of E2 expenditures that can be a part of your E2 investment. Definitely, you would want to work with a lawyer who can go through that expenditure list with you and can advise you on, where you can spend more or where you can increase the diversity of the expenses or things like that, such that you can present, a convincing picture that you have in fact spent everything that is needed to get that type of business up and running in the United States. All right, so let's talk about another very common question that we encounter with respect to the E2 visa is that, do I have to hire U.S. employees? And the answer to that is yes. And the reason is because of marginality. The E2 business must have the present or future capacity to generate enough income to provide more than a minimal living for the investor and the investor's family. And that definitely means hiring U.S. workers. That is the most direct way to prove that your business is more than marginal. So when you are applying for a new E2 visa for a new enterprise, you must demonstrate that you will hire employees in the next 5 years. You don't need to say that you will be immediately hiring employees, or it is not necessary for the business to already have employees by the time you apply with a new enterprise. But definitely, you must be able to convince the government officer that your E2 enterprise will, in fact, hire employees in the future. So our recommendation is to present a plan that will show that the E2 business will be hiring at least 3 to 5 employees, full-time employees, over the next 5 years. And to speak a little bit about the distinction between W2 employees and 1099 workers, W2 employees are employees on regular payroll. So full-time employees where, you would provide a regular salary and you would make the required deductions to, Social Security and things like that. Versus 1099 workers, we describe as, contractors, right? So these contractor employees are not included in, they're not considered regular employees, but are more like contractors. So when we compare W2 employees to 1099 workers, having W2 employees is definitely more advantageous in terms of marginality to qualify for the E2 visa, as opposed to 1099 workers. The exception to that, I would say, is if your industry is one that commonly relies on a high number of 1099 workers rather than W2 employees, such as, a beverage industry or food and beverage industry where you hire a lot of, part-time workers in 1099 status, then that may be understandable. Even in that case, though, we would still recommend at least having a couple of W-2 employees under your business to prove marginality. So definitely a case by case inquiry when we, present the hiring plan. But generally, W-2 employees are preferred in that regard. So how do you prove the capacity to hire U.S. employees? For a new business, a business plan may be one of the most important elements, and we will go into a little bit more detail on the next slide. You can also provide letters of intent from clients who are interested in using your business's services that will, show the business's capacity to generate sufficient revenues. If you are applying for an E-2 visa renewal, or if you are applying to qualify based on existing business, you want to show copies of the business's recent W-2s that shows that the business has in fact hired employees in the past, any pay stubs or payroll reports showing the number of employees that the business is currently, paying salaries to, and tax returns are also a very important element to show the business's revenue generation potential and profitability. All right. So when we speak of a business plan, what should the business plan contain in order to be a helpful form of evidence for either an initial E-2 application or an E-2 renewal application? The business plan would normally contain an executive summary that provides a brief overview of the core details of your business, who you are, what you do, and who do you sell to, what kind of services do you provide, what kind of products do you sell. And you would also provide a bit of market analysis and research that shows the market opportunity that exists in your particular area where you provide services or where you sell products, and discuss a little bit of the competitive advantage that your services or products may have. Marketing plan is also a very important element of the business plan because it shows that you do have a blueprint on how you're going to attract clients to earn that level of revenues that you are projecting for the future to support marginality. A personnel plan is also a very important part of the business plan. You want to tell the U.S. Government officer who you're going to hire to support your business operations in terms of employees. What are these employees' job titles? What are these employees' job duties, and how much salary are they going to be paid? So we do want to provide a very concrete picture of who's going to be part of your team when you're operating this business in the United States. And all of the salary information and things like that must make sense in light of the business's revenue model and the volume of business that the enterprise is expected to bring in. Now, we do want to also make sure to include a comprehensive financial plan with the business plan. So, for example, you can show a projected balance sheet for the next 5 years, projected income statements for the next 5 years that shows your expected the expected numbers on how much revenues you think the business will make each year. And it will be good to show, at least a little bit of upward trajectory on that to show the business, to show that the business will, in fact, reach that point of having at least 3 to 5 full-time employees and being able to support the salaries of those employees in the future. And yeah, include a cash flow statement to convince the officer that the business will indeed have enough positive cash income to support those operations.
Great. Thank you very much, Jiyae. So we will switch gears a little bit and talk about some specific considerations that have come up in recent years, and particularly in the new administration. So let's start by talking about USCIS versus the consulate. Jiyae talked about this a bit. During COVID, the pandemic, we saw there a significant spike in USCIS applications. And part of the reason for that was, of course, because borders were shutting down. People were not as free to travel. So you had a lot more people inside the US who had status, maybe student status, visitor status, and they wanted to apply for E-2 status from within the US. That is perfectly fine to do if you're inside the US. The things to consider are that there are significant limitations if you do decide to apply from within the US through USCIS. One is that if USCIS approves your application, you don't get a visa. You actually get E-2 status. So what that means is that if USCIS approves your E-2 application, you can stay in the United States in E-2 status, but the moment you leave, you need to actually go to a consulate to get a visa in order to come back into the US in E-2 status. So that's usually the biggest reason that someone would want to get a visa at a consulate, is if they need to leave the United States. The other thing worth considering is that a USCIS application tends to be more expensive than a consular application. Additionally, USCIS does offer an expedited option, which is a plus for USCIS. If you pay for premium processing, you can get an application decided within about 2 weeks. The downside of that is that that expedite fee costs $2,800. So it is not cheap. But if you do want a decision quick, that is going to likely be your best option. Consulates, in contrast, at the quickest, are probably going to call you in for an interview about 2 months after you apply. So, and that's at the quickest. There are things to consider between USCIS and a consulate. The other thing that's important to know is that USCIS will usually scrutinize the source of funds. So if you have clear documentation about where you got your money that you're investing in the business, this doesn't really matter. But let's say that you've had a hard time getting documentation. Maybe it's been difficult transferring funds from your home country to the E-2 company, or maybe you have cryptocurrency as your source of funds. Those types of factors would suggest that a consular application is probably a better idea than applying at USCIS. And finally, to quickly clarify, you can apply at a consulate whether you're inside the US or outside the US. If you're in the USA as a student, you can submit an E-2 visa application at a consulate. And then when you're called in for the interview, you'd fly to the consulate. If you're approved, get the visa and be able to come back in on the E-2 visa. In contrast, you can only apply with USCIS if you're inside the US. So source and trail of funds, Jiyae shared some important information on this, and I just mentioned this briefly. Both USCIS and consulates are going to require that you prove where you got the money that you're investing in the E-2 company. And what they're looking for is assurance that the funds were lawfully acquired. So, that is generally easy to show, and obviously most people, the funds are lawfully acquired. But that being said, the government does basically want an explanation of each step, from the source of the funds, whether that's work, whether that's selling an apartment, an inheritance, a gift, and the funds actually ending up at the E-2 company. So you do need to document that source and trail of funds. And USCIS is in particular going to scrutinize that. You can use loans as a source of funds. This is one of the benefits of the E-2 visa, is that the source of funds is actually quite broad. You can use income, you can use sale of an apartment, inheritance, gifts, loans. As long as it is lawfully acquired, in general, the source of funds is broadly acceptable. The exception is loans that are secured by company assets. So if you have a company in the United States, you go to the bank and you say, I want to take out a loan that is secured by my company, that is going to be a no-go with the government. They do not accept a source of funds that's secured by the company itself. So If you want a loan, make sure it's secured by your personal assets or an unsecured loan. So credit card, unsecured loan, that is also fine. Gifts are also acceptable sources of funds. The thing to know with gifts is that you do need to document where the person giving you the gift got the funds. So let's say they sold an apartment and then they got $1 million and they're giving you $100,000 to start your business. You need to prove exactly where that person got the money. You need to show they sold an apartment and how the funds flowed from the sale of the apartment to their bank account, and then from their bank account to your bank account, and then from your bank account to the E-2 company. Considerations for small investment amounts. I quickly want to note we have a separate webinar, full-length webinar that is specifically on this topic. So if you are investing $100,000 or less, I strongly encourage you to check out that webinar either live. We will certainly be giving that webinar soon. And we have it recorded on our YouTube channel. So do check that out. Our firm is very proud to actually regularly help clients who don't have a ton of money to invest successfully navigate the E-2 visa process. So one of the first steps we take in those applications is to look at the application holistically, because investment amount is one of several E-2 visa requirements. So even if that requirement, you have a low investment amount, you might be able to strengthen the application in other areas, such as, for example, hiring workers. If you have invested a low amount, but you're employing US workers and already generating income, that can be a way to minimize the importance of the investment amount. And we've seen plenty of approvals in spite of a low investment amount. So some things on your screen that you see to also address a low investment amount are letters of intent. So what those are letters from prospective customers or clients where they are saying, once this company is actually active, I want to do business with it and I plan to do business with it. And that's important for showing the government that in spite of a low investment amount, this is a business that is already generating interest and is likely to generate income and employ US workers. Second of all, a CPA letter. So a letter from a certified public accountant where the CPA is saying, in my experience, having looked at a number of businesses, I think that this business has received sufficient investment to be viable, to be able to become operational. So a letter from a CPA saying that can also be persuasive. You can, next bullet point, you can get an E-2 visa for two co-owners of a business. Now, keep in mind, Jiyae talked about this. The ownership requirement is that an E-2 investor must own at least 50% of the US company. So that means you can have a 50-50 ownership structure where there are two E-2 investors. You can't have more than two E-2 investors for a single business, but you can have two. One of the interesting aspects of this is if each of the E-2 investors is from a different country. So let's say you have an E-2 investor from Germany and an E-2 investor from Canada. That E-2 company will have dual nationality, meaning that it can sponsor E-2 employee visas for individuals from each of those two countries, Germany and Canada. So that can be helpful in certain cases. Next bullet point, substantive changes to the business after filing. This is a very nuanced point, and so if it's relevant to you, I strongly recommend that you set up a consultation. But sometimes you'll get an E-2 visa, the business will be running, and you'll decide to start selling different products or start selling different services. Sometimes this is perfectly fine. Let's say the E-2 visa is for a restaurant and you want to start a coffee shop that's under the same LLC. That's almost certainly not going to be a problem. But if you are running a restaurant and you want to start a consulting company on social media and marketing initiatives, that is a significant difference. So doing that, you do want to talk to a lawyer before you do something that's outside the scope of what you told the government the E-2 company would do. So one thing you can do is, if you think there's a chance you're going to expand the scope, put it in your business plan, put it in the initial application so that you have a good argument that, this was approved by the government. But if you didn't do that early on and you want to expand into a new area, talk to a lawyer. If you don't talk to a lawyer, you may need to explain to the government, if you're renewing, why you expanded the focus, hope that they don't have an issue with it. Or if you're before the renewal stage, you may need to apply for an amendment, which is basically you're telling the government you've changed. Please approve this change and give me approval. The final option is you can ask for an opinion from USCIS and say, hey, this is what we've done. In your opinion, is this a substantive change? And we've done this on a number of occasions. Oftentimes USCIS will say, that's perfectly fine to do. Sometimes they will say, this is a substantive change, and that will have its consequences along with it. Again, happy to talk about that through a consultation. Finally, there are certain types of businesses that are simply more risky. So meaning that the government is going to scrutinize them more closely, and there's a higher chance of denial. A couple of these, real estate and equity trading, are similar. The issue with these is that oftentimes the government assumes that if you're doing a business related to real estate or equity trading, you don't need employees, that you basically, you're investing in an asset and you hope that that asset increases in value, and that doesn't take employees. So in those applications, you do need to clearly show in your application why you need US workers. That's going to be shown typically in the business plan. Finally, family business purchases. So the important thing here is the definition of a substantial investment is an investment that is sufficient to get the business operational, or the fair market value of a business if you're buying it. So here, if you're buying a business from a close friend or a family member, you do want to make sure you're paying the fair market value. If you're getting a discount, then there is a good chance that the government will say your investment is not substantial since you did not pay the fair market value. So do be careful there. Common reasons for E-2 denials. Jiyae's already talked about a number of these. Low investment amount is a big one. Again, we have a separate presentation on that. Schedule a consultation if your investment amount is $100,000 or less. Depending on the consulate, that might even above $100,000 might even be low. So schedule a consultation if you have questions. We do look at those on a case-by-case basis and can help you navigate that. Nature of the business, I mentioned real estate and equity trading can be risky for the reasons I said before. Filing location or venue. So certain consulates are simply more difficult than others. We help our clients navigate that. You usually do need some ties to a country in order to apply at the consulate there. That can be residency, citizenship, of course, holding a passport from that country. It could be other things. It could be that you have relatives there. It could be that the consulate accepts third country nationals. So again, these things do change over time. We're happy to talk with you about that. Sometimes a common reason for a denial is that the applicant has a business that's very similar to the US business, and they've operated that business in their home country, and that business in their home country didn't employ workers. So let's take an example. If you want to start a restaurant in, say, a hotel in the United States, and you have this wonderful business plan, it shows you're going to have 20 employees within the first 5 years, but you had a hotel in your home country of Germany, and that hotel actually only employed you and your spouse. That's going to be a problem. And you're going to need to be ready to explain why you are going to do things differently in the United States so that that US company is going to employ people where the German company did not. So be ready to explain that. It's not something that you cannot overcome. You just need to be ready to explain, particularly with a business plan, what you're going to do differently so that that US company is going to employ people where the foreign company may not have. Next, sometimes there's just issues with the officer at the consulate. Sometimes officers have bad days. Sometimes they are poorly trained. Sometimes the consulate just does not see many E-2 applications, so they don't know what the E-2 requirements are. Some of these things you can anticipate and help with. So if it's a consulate that doesn't see a lot of E2s, you can walk them through in the application clearly the E2 requirements and how you satisfy them. But if it's an issue with the officer, sometimes there's just nothing you can do. And you just, officers have a lot of discretion. You may be denied. The positive side of that is that there, in general, is no prohibition on reapplying. And usually, if you reapply, consulates will try to assign the application to a different officer so that you get a fair shot. So do keep that in mind. But consular officers do have absolute discretion in these applications. So unfortunately, if they do not like some aspect of your application, they can deny. We keep that in mind as we prepare applications, and we try to give our clients the best shot they can possibly have. Finally, sometimes we will have people come to us after they have applied either with another lawyer or on their own and have been denied, and we'll see that the application that was submitted simply did not qualify. Maybe the investment amount was just way too low. They put money into the business account but didn't spend much. Or they didn't show that they were going to employ workers. Sometimes people just don't satisfy the requirements. So make sure you satisfy the requirements if you're going to apply. And if you work with us, obviously, we're going to flag anything that comes up and is likely to come up. So let me make sure. Okay, great. So when you are renewing an E-2 visa, the most important thing in general is that you are employing U.S. workers. So you do want to, as Jiyae said, apply in the renewal with tax returns, W-2 forms, payroll records, showing that you are in fact employing U.S. workers. We always say aim for at least 3 full-time equivalent U.S. workers within 5 years. If you have not hit that by the time you are applying, it is worthwhile to boost hiring, even if it's in the last month or two before you're applying to renew. Show that you have people on payroll, but try to do that earlier. It's the best piece of advice we can give in terms of renewals is focus on hiring U.S. workers early and hit at least 3 full-time equivalent U.S. workers by the time you renew. At the renewal, you'll also provide updated financial data. So this is the company's tax returns. The company should be profitable. It should be able to support the E2 investor and their family, in addition and after paying all of the U.S. workers. And of course, make sure the company still meets the E2 requirements. You have to always own at least 50% of the E2 company. So the moment that drops below 50%, you become ineligible for E2 status. So you want to make sure you always have 50% ownership. And as I mentioned before, make sure that you stay within the scope of what you tell the government the business will do. Finally, some trends that we've seen, particularly in this administration. E-2 visas do continue to have high approval rates. So according to the government, they approve E-2 visas about 80 to 90% of the time. Our approval rates are in the very high 90s in terms of percentages. Of course, I have to give the disclaimer that that does not ensure future performance, but we always do try to make our clients' applications as strong as they can be. It is recommended that your investment, as Jiyae said, you need to actually spend the money that you're investing in the business. You cannot simply have it sitting in a bank account. Though the money should be spent, at least half of it, in the United States. So if you're buying inventory and that's 90% of your investment, make sure that's not all spent in China. So make sure you're buying at least 50% of your investment is spent in the United States. The government, may be trending toward wanting to see higher investment amounts, although we still have plenty of success with lower investment amounts and can work with you on that. Buy American, hire American. So this is something going back to the first Trump administration. And really, the question might come up at the consulate about why U.S. workers. Let me reframe that. You want in your E-2 application to emphasize that you'll employ U.S. workers and that this will create jobs for U.S. workers. So that is a key part, probably more important now than it was in the past. Try to get employees rather than contractors, as Jiyae talked about. Administrative processing rates have increased, so the government will scrutinize applications and will engage in heightened scrutiny if there are any questions about the application. This can cause delays, unfortunately, but fortunately, this is the exception and not the rule. So you are not likely to be put in administrative processing. And wait times at consulates are not extremely long right now, nowhere near where they were during the pandemic, but wait times are likely going to increase, especially as increased scrutiny is applied to these applications. So we have 1 minute, so let me quickly fly through these questions. Does Scott Legal help screen and verify the business before we apply? So what we will do, obviously we have the knowledge of what we see and the many, many dozens of applications we filed. We're able to flag things in your application that we think are risky. So whether it's you're not showing that you're going to hire enough employees in your business plan, or your investment amount is low for that consulate, we will certainly flag that. We will certainly work with you on how you can frame the application in a positive way. And happy to discuss that during a consultation as well. An existing restaurant wants 100,000 to move out. Does that amount count as investment? I'm not sure exactly what that means. If you're buying a business, then the amount you pay for the business is certainly an investment. And if you're investing in a startup, that will certainly count as an investment. Schedule a consultation if that does not answer the question. What is the cost for an E-2 application? So great question. Please do reach out to us. We have an engagement letter. We have detailed information on our flat fee that we charge for E-2 applications. I'm not going to get into costs over the webinar, but we are very, very transparent with this if you do want to reach out and receive an engagement letter. And the way we structure it is E-2 is a flat fee. It is not hourly. So you have transparency in terms of what you're going to pay. We do, if you have a spouse, if you have children, if you want a business plan, if you want us to create the LLC, we're happy to help with all of that. And those are additional fees on top of that flat fee. Can my father and I be co-owners of the E-2 business? Is there any age restriction? There is no age restriction, and you and your father, assuming you both have a passport from an E-2 treaty country, can certainly be co-investors. Approvals are regular. It doesn't affect the chances of approval if it's you and your father as co-owners, assuming you have a good reason why you both want to be co-owners and co-investors. You do both need to satisfy the requirements, of course. So you both need to invest in the business. You both need to be operating the business in the US. I have become a Canadian citizen recently. Will there be any questions coming up since I recently became a Canadian citizen? No. As long as you have that passport, it should not be an issue. In fact, even if you have never been to the country where you have the passport from, you can still be approved. So as an example, Uruguay does not have an E-2 treaty country, E-2 treaty visa with the US. Many of Uruguay's citizens have dual citizenship with, say, Italy. Italy is an E-2 treaty country. So even if you've never been to Italy, if you have that Italian passport, you can still apply for an E-2 visa, even if you are a dual Uruguayan Italian citizen. I'm currently working as a software engineer. I don't have any experience. Will there be any question about the business I want to start? So it's okay if you don't have a lot of experience in the business you want to start. What I would say is advocate for yourself. The application should advocate for you. So it should show how, in spite of you never having worked in a restaurant, you're going to be good at working at a restaurant because you've done all these other things. You have been a good employee at these three companies abroad. So, you know, it is okay if you don't have experience. If you are the investor and the business owner, you really want to emphasize why you're going to be a good entrepreneur. And the last question, do we assist with business due diligence or just the immigration? We do not help you find businesses. We don't do that. We do look at, once you have found the business, we're happy to look at it, to look at the tax returns, to look at how many employees it has, and to give you an assessment of the strength we think will follow from that business. So any other questions, please don't hesitate to schedule a consultation. Really appreciate these great questions. We do hope to see you on future webinars. And stay well in the meantime. Thank you, Jiyae, for taking the time and sharing your expertise. We do hope to see you all soon. Bye-bye.
Thank you.